I'm the judge and the committee.
May it please Your Honour, I appear before the Crown and my learned friend Mr. Murphy is for the defendant. This is a
Can you shut the door please so we don't get the record and we're not disturbing next door? Sorry for having to interrupt you.
This is a response to the defence application for exclusion of the identification evidence of Mr. Simon. The defence is of the opinion that the video lineup was done in an improper way. The Crown asks the court to reject this application because there is no impropriety. This is on 3 grounds. I will come to these grounds in a minute. Has Your Honour had an opportunity to read the skeleton argument?
I've looked at it very briefly, Mr. Krugman. So please, and I'll bring it up now, please refer me to any parts of it you wish to. Can I ask you though, before you do that, that you slow down when you make your submissions, because I have to take a note of what you're saying, and also this is all new information for me, and it's important that I understand your application.
Much obliged, Your Honour. May I briefly run through the background of this case?
Well, I have of course heard the submission of the defence, so I do know what the facts are, because I've just been told them, haven't I?
Yes, that's true, but I want to highlight the important facts.
Please do, take your own course.
As Your Honour already heard, the defendant was arrested on suspicion of being a drugs dealer, and that the defendant was also arrested.
Just pause for a moment. Have you got the SD card?
Yes, Vivian's given it.
I'm sorry again to interrupt.
And you heard that the witness also was arrested because he was recognized by another PC as being a known drug user.
Yes.
He was arrested for suspicion to conspiracy, but he was later released under investigation, and no further charges have been put laid upon him. So that's important because he was asked back to the police station on the 16th of January to do video lineup, and he went voluntarily. So they needed to pick him up, and so he went and did the video lineup. And the defense states that the video lineup was in breach of Code D of the Police and Criminal Evidence Act, and especially Section 78 is especially important for this submission, and Sections 3.4, 3.5 and Annex A of the Code.
Yes. So what I'd like to know really from you is what do you have to say to that objection first of all?
Well, in any case, if it was a breach, it was a breach that was so minor that it does not warrant exclusion of the identification evidence. You know that the breach does not automatically lead to an exclusion. See the Crown and Delaney. This is your...
So can I just ask you this? Do you say it was a breach or it wasn't a breach?
It wasn't a breach.
Right.
But in any event, if it was a breach, then it shouldn't lead to exclusion.
Okay. Why do you say it wasn't a breach? The defence say it was a breach because no first description of the witness was recorded. And secondly, they say that the witness wasn't shown the procedure twice.
I will get to your first point in a moment. I would like to do the second point first, so the not shown twice.
Certainly.
And that all well and good, but Your Honour must remember that it wasn't. The code was not breached by the police or was caused to be breached by the police. It was Mr. Simon who did not follow the rules. And it would have not have mattered if he followed the rules, because Mr. Simon was able to identify the defendant fairly on the first occasion. So, what did the police have to do? Jump on him and say, no, no, no. He blurted it out before he could be stopped. So, it wasn't a breach of that specific code by any means, because the police didn't breach it.
Yes.
It was Mr. Simon. About the second point, and I thought about this before, and I don't believe the police needed to write down the description, because the police, the man was known to Mr. Simon. He said so at the time. He said, that is my drug dealer, and I saw him flee the building. So he knows the man. Why would he write down the description of that man if he knows him? And in some cases you do a proper lineup, and in some cases you do a video lineup, or is taken to the situation in situ and do a car lineup.
Yes, well, I'm aware of the procedures. But
So
what you said about the defence point is that he wasn't even asked to give a description, and they say if he'd been asked to give a description, he at that stage may not have, is dishonest, he may not have known it was Wayne Beeman the police were interested in, because at that stage he hadn't had the chance to see Mr. Beeman in the police station.
But he
And therefore he might have given a description of somebody entirely different.
That might well be the case. If he said it was B, he used the name B, and as we now know, it was Beeman. So
I see.
he had a name, and he knew who he was. So there is no collusion or dishonesty, because at the moment of arrest, he said, "I know the dealer. He's called B." So
yeah, that's very helpful. All right. So that's the identification period, and you say there isn't a breach. If I find that there was a breach, you say that it wasn't so substantial that it should be, it should render the identification evidence inadmissible.
that's correct, and that's the first.
All right. What do you say about the Crown of the defence's other objections?
Well, the defense said that there was collusion by Mr. Simon and the police when Mr. Simon was in custody, but there is no evidence for that. So there's no evidence for it at all. If that, so you can exclude that ground anyhow. So and.
Well, there's some other evidence, isn't there? Because they were in the police station at the same time.
Yeah, but
and Mr. Simon said to the police that he might be prepared to assist them if he was given something in return. Does that not form a seed of suggesting there may have been some collusion?
The custody record states that they were in the same cell block, but I don't believe it states that they were in and out at the same time. So, and although he said, "I can help you," there is no evidence of any offers by the police or the CPS that would assist Mr. Simon in any way, because there was no evidence for the charge of conspiracy, so
charge of conspiracy against who?
Against Mr. Simon. So the case wouldn't have been brought to court anyway. So,
okay, so you're saying Mr. Simon didn't get anything out of it, basically?
That's it. So he didn't need to lie, and that brings me to the point of his previous conviction, that it was perverting the course of justice, but that was when he had to gain something, he lied. And it's my point that in this case he didn't have to lie because he gained nothing because he was promised nothing.
But you might have thought he would gain something.
Yes,
Yeah,
that might well be, but and the reliability of the statements and the evidence of Mr. Simon is all a matter for the jury.
Okay.
Can I assist you any further?
Thank you very much.
Then
Thank you.
these were my
That's
submissions.
helpful.